All right, Bannock County Commissioners are back in session. I'd ask for a motion to go into a public hearing.
Mr. Chair, I move that we open the public hearing.
We have motion, all in favor say aye.
Aye.
Aye. So this is a public hearing for the transfer of development rights for building purposes. The process in this hearing will be that the hearing is for public comment and is not a question or answer session. Everyone shall exhibit respectful behavior. There shall be no booing, hissing, or cheering. Please show respect for all opinions or comments given. Only one person may speak at a time and must be recognized by the chair before speaking. We've had a sign-up list that will call people up. They'll come sit in this chair and give their name, and they'll have 3 minutes to make their comments. This buzzer over here, the white light will come on when you start, and the red light goes on. That means your time's up. If anyone does not want to speak or would like someone else to speak in their behalf, we do not allow that. In addition, if you are angry or upset, that's okay, but please don't take your anger out on the commissioners or the staff. Does everybody understand the process of the proceedings? Okay. So we have written testimonies. Cody and Natalie Scotland.
Yep.
And we've reviewed that. That's in our packet. We also have Lynn and Marge Stewart and Leanne Christensen and Justin S. Tobias. So we had those packets. They're in our packets and we've read them. So for the record, they're part of the record. So first off, we'll start off with just comments about what we're here for. And we'll go ahead and turn to staff to do that. And then we'll invite people up to give their comments. And then we'll close the hearing and the commissioners will have a discussion and we'll go to that point.
Thank you, Commissioner Hal Jensen, Planning Director, Bannock County. I have with me Tristan Borkwin, Assistant Director.
Excuse me, could you speak up just a little bit?
You bet. Previously, a public hearing was held for the transfer of development right. Mr. Justin Tobias came to the office, asked the process and procedure. We explained it to him. He filled out the respective forms, made his application. It was public hearing was held as required by state statute, one of two hearings. The Planning Council found affirmative in all of the required elements of the transfer of development right and made a recommendation for approval to the commission. And so we're here today for the second public hearing relative to the transfer of the development right as requested by Mr. Justin Tobias.
Okay, thank you. First up, I have Margie Stewart. Please introduce yourself, where you live, and your time will begin.
Margie Stewart. I live at 8574 South Bob Smith Road, Lava Hot Springs, Idaho. We live in the property across the road from where this property is, and we've been there. We built our home in 2000. We built there because it's a nice, quiet place. We are surrounded by agricultural property. We enjoy the quiet. We enjoy the not a lot of traffic on our road and the beauty around us. We've eventually got neighbors. Each property that has built on Bob Smith Road, across from us is 10-acre pieces. The property in question was originally 10 acres, and the people that built the house sold the home and separated the property, so that now there's 2 pieces of property on that 10 acres. And if it was an individual family home, permanent residents, that would be different. I still wouldn't like it, but that would be different. This is going to be an overnight rental, which is possibly going to cause more traffic up our road, possibly going to cause people with ATVs running up and down our road. All of the property surrounding this property is private property. There's no public land right on that road. We're concerned about that. We're concerned about strange people coming and going all the time. The possibility of people coming on our property is a real concern. But we bought where we bought for the quiet and for the peace and for the beauty that's around us, not to have an abundance of neighbors and not especially to have an overnight rental. So, and I would not like to see another home on that property myself anyway, but especially an overnight rental is very concerning. So.
Okay, thank you.
Thank you.
Lynn?
Yes.
Okay.
Lynn Stewart, 8574 West Bob Smith Road. I just wanted to approach the commissioners with some things that took place. When we had the hearing with planning and zoning, the fellow that's wanting to transfer these development rights really misled everybody. He indicated that his property was, that he lived in Lava. He does not. He lives in Ogden. He's a dentist. His practice is in Ogden. He has a summer cabin that in Lava, but he used that as his address. I think it's wrong that he implied that he was a resident of Bannock County. The land that's being developed, the development rights have all been used up. And I think it's wrong that he can purchase a piece of property someplace, just any place, and then transfer that right to build in the area that's already used up. And I just wanted you to understand that I think that's wrong. Whether it's a overnight rental or whatever his plan is, for him it's an investment. But we live there. We have to, he may make money, but it'll be at our expense. So I just wanted to indicate that we feel pretty strong about this. Thank you.
Thank you. All right, next I have Thornley. Christie?
Yes. Hi, I'm Christy Thornley. My dad was Delbert Bruder and has property on Bob Smith Road. I don't live there. I live in Tremont, Utah. My parents have passed away, and so now I'm 70% owner of that. And I didn't know I signed up to talk. So yeah, I was just trying to find out what this was about because I got this letter, so I thought it was important to come. I think with our property we have a right to, I'm sure we have a right to build with the property that we have, which my parents was going to build. And I just wanted to make sure that it wasn't that one that was trying to get transferred. That was why I was here. So, sorry.
No,
Didn't know I signed up to talk.
You're good. That's fine. Thank you. Natalie?
Natalie Scothern, 8873 South Bob Smith. I just would like to come and talk about this. The property that this is going, when our neighbor sold this and then divided it for this 5 acres, we offered to buy it as an agriculture, to keep it in agriculture, and it was priced astronomically high. There was no way we could afford this. We would love to have bought it. We wanted to keep it in agriculture. So then it was sold, and now this is happening. This is right next door to us. When we moved from Utah, we uprooted our entire family and brought our girls up here to raise them in an agriculture area because Utah it's being overdeveloped. We didn't want to be a part of it. We came up here, when we looked at this property, the seller told us, Jeff Harris said, the best part about your property is everything right to the side of you will never be able to be developed on. And we were like, okay, so I called planning and zoning when we were looking into this and asked, and that was the exact answer I got. No one would ever be able to build next to you. Everything was already divided up, everything was done. So this is very upsetting for us when this was not what we got into. We were misled. We don't want to be that close to someone. We want to keep an open area. And it's, considering it's less than 5 acres, you look at rural residential, that's a minimum of 5 acres. We're in an agriculture zone. It's less than 5 acres. We made this decision as a family to come from Utah, uproot, and put our roots down in Idaho with our girls. This is a guy that doesn't want to do that. He has a home up Bob Smith with 40 acres, a cabin. He has a home in Marriott Sladeville. He has his company. He's on the planning and zoning there. He has no intention of coming up and making a home. This is an investment, and it is something that personally involves us. And I just wanted to express my concern. Thank you for your time.
Thank you. And Daryl?
My name's Darrell Christensen. I live at 8450 South Bob Smith Road. And I emailed, evidently it wasn't in your packet because you said it wasn't there. I emailed the letter in. So I will read the letter I read in and make comments time permitting. Dear Commissioners, we are opposed to the request by Mr. Tobias. We own property half-mile north of this parcel and are the largest property owners on South Bob Smith Creek Road and have lived there since 1971. Arkansas Ranches is a third-generation corporation, family farm and ranch. For decades, our family was the only residents on this road, and public access ends where the road enters our property. But we allow Bannock County Road and Bridge to turn their road equipment around on our property as they need to. We are believers that landowners should be able to use their property however they want, as long as it's legal and doesn't impact neighbors negatively. Let me share a little background on the property involved in the request for this transfer. Max and Karen Hall were longtime neighbors and owned the property south of ours all the way down to the Portneuf River. They had 5 children, and when the youngest 2 were adolescents, they had family issues resulting in divorce and related challenges. Max first sold his home and adjoining property and then started to sell off parcels with developmental rights to pay off the divorce settlement claims of his wife, and he gave each of his 5 kids parcels also with developmental rights, which is yours. Anyway, these 5 kids, only one built on the property, on those developmental rights. The other 4 sold theirs. After that daughter sold her home, it was bought by people in Nevada. We instantly started to have trespass problems with people from Nevada coming up riding ATVs, even though we have our property posted. I had to go there and threaten them with prosecution if they did not desist. The old couple was good about it, but when they died, the heirs started to use it as a rental property. And not only were we suffering trespass problems at that point, we started to suffer vandalism issues. And good luck getting Bannock County Sheriff's Department to respond in a timely manner. This property If he paid the asking price for this property of $85,000 for 4.32 acres of agricultural zone land without any developmental rights, that translates into $19,675.93 per acre. There is no agricultural ground in southeast Idaho that has that kind of land value.
Okay, thank you. Comments?
No.
Questions? I got a couple of questions.
Do you want to close the public hearing
Yeah,
first? or want me to
yeah.
go
Go ahead and close the public
Okay.
hearing.
on? Mr. Chair, I move that we close the public hearing.
We have a motion, all in favor, say aye.
Aye.
Aye. So, what is the lot size or acreage size required in an ag zone?
So there's two separate distinctions. There's lot size and then there's density. So the minimum lot size in the agricultural zoning district is 1 acre. The overall density is 1 dwelling per 40 acres. So if you have 1 acre for your house, you have to have an additional 39 of open or undevelopable land to make up that density of 1 to 40.
So, and that's my question on this one, as I read through here. If Max Hall separated these and went to the smaller density or smaller, how can we do this?
Yeah, so in the transfer of development rights section of our ordinance, it talks about what the criteria is to be able to transfer development right. One of those is that it has to be agricultural zoned. So the only areas that you can transfer are from ag to ag. It doesn't specifically say they have to be contiguous. They just have to be in Bannock County and zoned as agricultural property, which is what this one is. When Max Hall went through and divided all of his, he had a bunch of 40 acres in that area, and so he transferred each one of those 40 acres to these 10 5-acre parcels that now have homes built on them. What Justin Tobias is trying to do, he has 80 acres in Bannock County. It is zoned agriculture. He's taking one of those 2 development rights from the 80 acres and transferring it to the 4.3 approximate acreage property, which still gives you an overall density of 1 dwelling per 40, because now that 40 acres will not be able to be developed in the future.
And that's within the whole of Bannock County, not in.
Correct.
And it's in an ag, which doesn't make a lot of sense to me, honestly. And then the other part with that is, we talk about our open space and stuff like that. This ground, in one of the letters, it said it was designated as the open space.
Yeah, so there's no designated open space in this area. The actual designation of open space happens through a subdivision process. These properties weren't subdivided through minor land division or platting process, which is where that open space requirement would kick in. These were divided using that transfer of development rights process. So the open space is kind of built in where those 40-acre parcels now don't have development rights. That's where all of the open space is contained in one large area, and then all of the houses are contained along Bob Smith Canyon.
So in these properties that were subdivided and designated, how many houses have already been built there?
How many houses are up there? There's probably,
I don't know.
6 or 7, I would say.
And isn't it that if you do 3, then that's okay, but if you do 4, then that has to be plotted and a subdivision?
Correct. And that's in our current ordinance. I believe a lot of what Max Hall did was prior to what we have for a current transfer of development rights ordinance. And it was through records of survey, which in our prior to 2019, I think is when we amended it, the lot of record definition allowed a record of survey to create a development right. So he did a record of survey, not a minor land division or subdivision.
It's confusing to me because it sounds to
It
me
is.
like we have a set of rules and now we've changed them for something different. Am I out of bounds here?
I don't believe so, Commissioner. The transfer of development right, when the ordinance was put together in 2019, it was to clarify and bring things into compliance with state statute. As Tristan said, under the old ordinance before this, as well as prior to 97, someone could actually just go do a record of survey on a piece of property, and it had a development right in Bannock County under the ordinance, which is basically what, to the best of our knowledge, that's what Max Hall did, okay? To give you a bigger picture, to understand density versus lot size. You can have 40 acres, and you can have one residence on that 40 acres, and that lot size out of that 40 can be described as 1 acre, with the remaining as part of the agricultural zone, etc. The reason that it's done that way is that most banks will not lend on 40 acres for a residence. It's typically 5 acres or smaller. So it's done that way a lot for lending purposes. But it meets the intent of our ordinance, okay? If you take Bob Smith Canyon and you have 160 acres, okay? You can take and put all of your development rights concentrated in one spot and leave the rest of it as an open space, okay? And that's basically what has occurred. The state recognizes that you're going to take 40 acres that sits in some location in the ag zone. You're going to move it over into a concentrated corridor. And you still have the density of 1 to 40. Even though this is a 4.32 acre site or lot or parcel, that 40 is now no longer able to be built upon, which then becomes, quote unquote, for lack of a better description, open space. So it meets the intent. All of the processes that go into this and all of the rules and regulations, it meets the intent and complies with our ordinance. And yes, it is confusing, and unless you spend time in it 24/7, it's hard to understand, but it is allowed.
Mr. Chair, if I may.
Yes.
So state statute allows the transfer of rights from a piece of property over here to a piece of property over here.
Correct.
Okay, because I was under a different misconception, or
So-
the misconception that you could do that, everything had to be contiguous, which,
Let's assume that somebody has 40 acres, okay? And they've built on that. And they decide that they would like to sell 10 acres of the 40. They don't have a development right because they only have one development right per 40 acres. That person that wants to buy the 10, if they go to another customer per se that has a piece of, let's say he has a 40 that's up adjacent to like very, very difficult terrain that just will never be developed. It's a 40 acres that sits in the mountains and it just will never be developed, but he owns it. He literally can take that development right and put it on the 10 acres.
but that 40 acres that's in the mountain has to be zoned agriculture.
That is correct.
In order to do that.
And so now you can take and have a 30 and a 10 on that 40, and it's compliant with state statute and our ordinance. And that's basically what is taking place here.
So-
And just for an added clarification too, the agricultural zone to ag transfer, that's from our ordinance, not from Idaho code. So Idaho code states that counties have to create an ordinance on how they want to deal with transfers of development rights, but there's no requirement on what type of zoning it has to be. So some counties in Idaho actually require ag development rights to be transferred to residential suburban or any other district not in ag. Our ordinance is specific ag to ag.
So ours is a little bit more restrictive than the state ordinance and some others.
Correct.
Okay. Second question is, we don't have any legal basis to approve or deny based on what they intend to use it for. Like it's been expressed, it's going to be a a short-term rental property, is there any legal basis to deny it based on that?
There is not.
Just as a comment, Airbnb has not been regulated, shall we say, or non-occupied residences for rent in the state of Idaho. And the legislature has chosen not to go down that path. Very adamantly said, we will not regulate. The only regulation that is in place for Airbnb is that they are required to be registered or filed with the state tax commission. That's the only place that we have a regulation, and that is outside of the purview of our ordinance and our regulations. So regardless of what the use is, if they came to us and said we want a building permit, we cannot deny it based upon the use. It is a residence by definition, end of discussion, whether it's occupied or unoccupied. Should the commission choose to go there, you possibly could. I only know of cities in the state of Idaho that have chosen to regulate non-occupied residences.
No further questions.
Do you have a motion?
Before I do, though, I would like to say thank you for your letters and your comments and your concerns. I am familiar with the Bob Smith area, and I love it. I think it's beautiful over there. But at the same time, legally, I don't know if we have room to stand on to say no to the request. So it is, and
Can we make comment, or are we not allowed?
we're done at this point in time. And I'm a big property rights guy, and I understand your comments about infringing on your personal property rights and what you bought the property for. So I get that, but I also see the other side of the story as well. And this is a tough choice. I hate making these choices, but at this point in time, Mr. Chair, I see no legal grounds to deny them the request. So, Mr. Chair, I move that we approve the request of transfer rights as presented.
We have a motion. All in favor, say aye.
Aye.
Aye. There is a process of appealing. Would you explain that, please?
Yes, so from today, there is a 15-day reconsideration window. There's an application through our office. It's online. You can come into the office and we can help you, or you can get onto the website and apply. And it's called a reconsideration of commissioner's decision. And it would come back before the commissioners within 60 days of receiving the request to reconsider, and then they would go back through. And it's not a public hearing, so there wouldn't be any public comment or anything, but they would go back through, review what's already been reviewed, and then decide whether they wanted to uphold their original decision or overturn their original decision.
Can I ask a question now?
Let's go ahead and close this meeting.
Okay.
So we are